rise for appeal for the 5th District, State of Florida, session. Now, William D. Palmer, Chief Justice of the House, alternate saying, this is for this court, drawing your good attention, and you shall be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left is Judge Orfinger. All the cases on the docket today are civil cases, so each side will have 20 minutes. The appellant can save as much of their time for rebuttal as they choose. First case on the docket today is ASHEMIMRY versus NAFA.
May it please the Court, I'm Patrice Talisman on behalf of the appellants NASIR ASHEMIMRY, Ash Trust Investment Corporation, Herald Full Service Hotels Limited, Orlando Investment Limited, and Sterling Hotels Limited. This is an appeal from a final judgment against the defendants on claims of fraudulent inducement, conversion, and civil theft, all arising out of investments by the plaintiff, SHEIK NAFA, in some of the appellant companies. Defendants' first point on appeal is that they're entitled to judgment in their favor. One of the essential elements of fraud and the inducement is justifiable reliance. The party asserting the fraud must assert and establish that but for the alleged misrepresentation, he wouldn't have entered into the transaction, in this case made the investments in the company. The misrepresentations must have been a substantial factor in the decision making. Here, SHEIK NAFA's testimony as to what he relied on in investing in Herald Full Service Hotels and Orlando Investments was very, very limited. Originally, he testified that it was solely his trust in American companies. This is from page 319 of his testimony, and it sounds a bit strange because it's being done through an interpreter. So he said that understand the mindset of us in Saudi Arabia. We look at America as the place of integrity and trust of investments. So when somebody comes and says American company, we trust that if it's registered with American government and it's something that is legal in America, we go with it. However, the Sheikh also admitted that he was given an information memo as to Herald Full Service Hotels. And that information memo disclosed that the company was a Cayman Island company, that it was privately held, that it wasn't registered with any regulatory agency, securities commission, or exchange.
Could you help me just with the timeline? The primary discussions, or I guess the only discussions, occurred between the Sheikh and the other gentleman whose name escapes me. Khalid. What's the timeline with respect to when those discussions were made, when the disclosure document was provided, and when the initial investment was made? Could you help me understand this time?
Yes, I can try. And I'm not going to be exact on the months, but it was the discussions with Khalid, and there was nothing very specific as to when he said X and when he gave me this document. But the discussions and the providing of the information memorandum and the initial investment all seem to have been done at about the same time. And I believe there was an investment of $175,000 and then two more investments, bringing the initial investment in Herald Full Service Limited in the fall, maybe the spring and fall of 1995. And then, so that was the first $3 million. And then several months later, there was a subsequent investment of $3 million in Orlando Investments. Does that help you sufficiently? But
is there any obligation? I mean, it seems apparent that the universe of investors that your client was targeting were folks from the Middle East, and specifically Saudi Arabia. Is there any obligation, if they're going to prepare an offering statement and disclosures, to then put it into the, apparently the Sheikh doesn't speak or read English and depended upon Khalid for translations. Is there any obligation that you're aware of that would say if you're going to solicit people who are non-English speakers that you have to put it into a language that they at least speak or read.
That hasn't been raised, but to my knowledge, there is in fact no obligation. I know that it has been asserted in cases in Florida, and none of them were cited because this was never an issue, that that the plaintiff in a breach of contract or a fraud action was Hispanic, and the contract was in English and wasn't in Spanish, and the court has said that didn't matter. Then in fact he was still bound by the...
Sure, and I can appreciate that, because if we're here in the U.S. and the target market is primarily English speaking, that'd be one thing. But if they didn't raise it, then I won't.
It wasn't, and in fact he signed documents. So obviously, if he wasn't comfortable signing the documents, he shouldn't have signed it. It is a question of justifiable reliance.
I won't waste your time.
No, I appreciate it.
The reliance issue would apply both to initially making the investment and making additional investments, correct?
Yes, Your Honor.
And there was some evidence, as I understand it, that misrepresentations were made to him about what kind of return he was getting on his money, which led him to keep his money in or give more money in to
the Sheikh, when he testified, his testimony is at 319 and then at 345 and 346, and he specifically asked, so what made you make these investments? Oh, and actually at 345 he talks about the first 150 was given in April, the next 150 was given in April of 95, the next 1.7 million was given in June, and
when was the document signed?
I have it right here, the stock purchase agreement, the original, the 30th of April, 1995.
So it was either simultaneous.
It was simultaneously with these documents because it was a stock purchase agreement.
It was, okay.
So at the very least, it was simultaneously with. And in that stock purchase agreement, and then the last one of October of 95, he talks about how, no, it was these statements, not and the additional return. And there really wasn't there was, I think, one further meeting, possibly, in between the initial $3 million investment and the second $3 million investment. And in fact, the Sheikh testified that what really convinced him to deposit or purchase the shares in Orlando Investment was going and seeing the hotel that they were going to engage in negotiations on. So the Sheikh did not testify that it was actually the additional meeting, or it was the fact that they said, here's I believe they said, you've made $108,000 and it's a stock certificate, we're reinvesting it. They never actually gave him any money or anything like that. So the Sheikh didn't testify that that was in fact a controlling factor or a substantial factor or a but-for factor. And as we've discussed, the stock purchase agreement not only talked about the offering memorandum, but it expressly has him admit and declare that I've read it, I've received it, I understand it, I agree with it. So these representations that it was an American company and all of that are certainly contradicted. And then when you look at
was the alleged fraud prior to the signing of the document?
Yes, Your Honor.
So
prior to the making.
We're not necessarily bound by representations in the document if the document was fraudulently induced to be signed in the first place, correct?
Your Honor, what the case law says, and we're not talking about, I know they've cited some cases on merger and integration agreements, but what the case law says is if you say that you were induced by a statement and that statement is then contradicted in the written documents that you receive, you cannot justifiably rely on the original oral statement. It's because there is a contradiction. There is no justifiable reliance. It's not simply that I tell you there are no representations and you don't have to take my word for it, that type of boilerplate language. But the fact that the representation itself that you're supposedly relying on is expressly contradicted in the agreement, such as Herald Full Service, Orlando, is an American company. Well, the information memorandums show that, in fact, they're Cayman Islands companies, and they expressly say that they're not registered.
What about the representation testified to concerning the 70-30 split, that the Sheikh would be putting in 70% and that 30% will be invested by by the other gentleman. Was that also contradicted?
He never expressly testified to that, and in fact, it's not covered in it.
I'm looking at Banafa's testimony.
And I understand that Mr. Banafa talks about.
So him saying that there would be a 70-30 split, and that he was interested in someone investing their own money in the project to make sure that that person put the time and effort into the project to protect his own investment. That was testified to by Mr. Banafa, wasn't it?
I agree that Mr. Banafa, or Sheikh Banafa, testified to many things that he was told.
Well, was that contradicted by what was in the documents that you're referring to?
What was in the documents, I believe what was in one of the offering memos, that was Ash Trust would invest up to $3 million. There was never a specific representation that they would, and that was the written representation that was made. Never that they would invest a specific 30%.
And that what about his testimony concerning the hundreds of employees that was
Your
that
Honor,
also contradicted
I agree.
by the documents?
He did say that there were hundreds of employees, and there was no test. That in fact was not accurate, and it wasn't covered in the documents. However, that is one of the few representations that you could actually say that was false, that was not contradicted, that was not puffing. And he certainly never testified that that representation alone was sufficient to convince him.
He certainly testified that was one of them.
Yes, that it was one of them. But when you take away everything else, is my problem. You're saying, okay, but he said there were 10 or 6 or 7 different things that he relied on, or that it was an American company. And then in redirect, he comes back and says, well, also there was this and there was
Well, he
this.
also said that there was $100 million or $100 billion invested in the company.
And he doesn't actually say he relied on that. He does say that he was told that. And the offering memorandum showed that, in fact, there was 1.5 million, that as of for 1995, there was going to be $1,500,000 in shareholder assets, and I believe in cash and investments for 1995, and a shareholder equity of $18 million. So certainly his testimony that it was $100 million is contradicted by the documents that he had in his hand.
Let me ask you to shift gears for just a minute, because I know you're going to want to save some rebuttal time. I want to ask you about the trebling of the damages, and specifically your argument as it relates to the interest component.
Yes, Your Honor.
Your argument is that the only investment that was testified to into Harrell was $3 million.
Yes.
And that and when you do the math, it's roughly $2.62 million in interest, and that was improperly trebled.
Yes.
Is that argument waived either by not objecting to it at trial, or, and I think more specifically, by not getting a verdict form which differentiated between liquidated interest that would have accrued on the amount and the principal?
First, let me say it certainly wasn't waived by objecting to it at trial, because clearly the parties have the right to prove up prejudgment interest, right, and when an amount of sum is stolen.
Right. I'm not so much concerned, because I agree that the trebling is afterwards.
Right.
But what about the differentiation? So you could say specifically, well, the jury awarded, X in principal and Y in interest.
Again, an argument that hasn't been made by the other side. What the other side said was that we waived it by failing to file a motion for remittiture. But since the jury obviously had the right to award prejudgment interest, remittiture wasn't appropriate. In terms of whether or not we had to ask the jury to make that apportionment, I would understand needing, well, first of all, I don't know. I've only, usually things like that are covered in two-issue rule, and two-issue rule talks about how you only have to make differentiations and ask for special interrogatories between different claims, so that if it's negligence and proximate cause, you don't have to split it up, and here you have different elements of the same damages. So the Florida Supreme Court has not to date taken it as far as elements of damages need to be apportioned. But beyond that, in this case, the testimony as to the amounts that were in fact deposited were undisputed. There were a lot of disputes in the evidence, a lot of contradictions, but the amounts that the SHEIK deposited were undisputed. So it is quite clear that of the $5,620,000, $3 million was $3 million was the amount that was deposited. That's the only amount the jury could have found, and the additional was prejudgment interest.
Well, the additional was sort of close to the interest number, right? It wasn't exact.
It was, but
there's no way we can know for sure how the jury got to the exact number they got to.
We don't know what exact interest rate they decided was appropriate versus the interest rate that the expert testified to. But we know that...
Was there a dispute? Was there argument about using different interest rates?
I think he gave different amounts. I believe he used different interest rates.
For different years, right?
Yes.
But not...
But the jury isn't bound by expert testimony. I mean, the jury doesn't have to say, oh, we like that number versus we think the appropriate interest rate was X.
Well, the jury couldn't apply a prejudgment interest rate different than what the law dictates is the prejudgment interest rate, could they?
I don't think that necessarily, in terms of prejudgment interest.
You think the jury could say, we think 1%'s enough, and that
Yes.
wouldn't be challengeable?
I don't know. I know that no one here is challenged that it was in fact prejudgment interest or that the rate or the amount was inappropriate because it was in fact relatively accurate. I mean, juries get to award prejudgment interest. I've never seen anything that says it has to be correct to the penny.
Is the statutory rate of interest that's in, I think it's in Chapter 55, which is, I think, what he used.
That's what he used.
Is there any case law, and I'm trying to remember, I know that applies to post-judgment interest, but does it necessarily, as a matter of law, apply to prejudgment if the amount isn't otherwise liquidated in a contract?
I don't know. I mean, certainly if there were a contract that talked about it, then you could use the contract rate. I have no idea, Judge.
Is the argument?
I don't either, so no.
Is the argument that you're making to this court about the trebling and about the prejudgment interest different from the argument that was made to the trial court?
I don't think so, Judge.
I thought the argument to the trial court was it shouldn't be trebled at all. Wasn't there an argument made to the trial court against the trebling?
I think he also complained about that the judge had originally trebled the interest as well. So I believe that that it was pointed out to the judge that it was incorrect in the motion to alter or amend the judgment, that it was incorrect to treble the interest damage. So I believe the exact argument is made. He may have made additional arguments as well, but that the exact argument was also made. And the case law is quite clear, and I've cited some cases, I know they aren't directly on point, that talk about when the intent of the jury is clear, the court can go ahead and correct that intent. And here I think, based on the undisputed evidence as to the amount of the investment, that the rest of it is prejudgment interest, that in fact the intent is clear and that the judge should have simply trebled the $3 million to $9 million. Now I'll reserve the rest of my time for rebuttal.
You've got about 3 minutes.
Thank you.
May it please the Court, my name is Don Conwell and I represent the plaintiff SHEIK NAFA. On the issue of reliance, we've covered that pretty well, I think, in our brief at pages 7 and 8. I heard from the questions asked by the panel that the very representations that he identified that were made to him that he relied upon, the panel has already noted. I would say in addition to those representations which he identified and answer the question, what convinced you to invest the money, which is a reliance issue, that there's also a fraudulent omission. I wanted to address that because in the reply brief, to which I have not yet responded, they say that there is no duty to make a disclosure unless there's a fiduciary relationship. I have two responses to that. The first is that there is a fiduciary relationship because Mr. ASHEMIMRY held himself out as an investment advisor to SHEIK NAFA, and that is a relationship of trust. And then the second issue is that the law in Florida is that when you undertake an obligation to make a disclosure of material facts, you have an obligation to make a complete disclosure. You have a duty. Two cases I would just cite to you. One is ZC Insurance versus Brooks out of the 4th District, where there was a disclosure document that disclosed the certain insurance coverage, but then they failed to disclose another document that identified the exclusions from the coverage. And they said that having made the first disclosure, there was then a duty as a matter of law to disclose the document that identified the exclusions. Also, Nicholson versus Kellen, which is out of this court, 1985 decision found at 481 Southern 2nd at 931, said the same proposition of law that you have a duty to make a full disclosure once you undertake making a disclosure of material information. On the issue of opinion, she brought that up several times. This was just an opinion. The statements that were made here, I don't think, could be qualified as opinions, and in any event, they could not, or they are actionable fraud because they're made by someone with superior knowledge, and they're made, in this case, with an intent not to perform them. The Magia case that we cited, I think, is probably the clearest case on this point. But in this case, there were representations made that you were going to get a high return, you were going to get 30 to 40% returns. The offering memoranda identified a return, but there was never any intent to invest in anything. The evidence in this case showed, and we pled, that this was a scam from the start. This was just setting up phony, non-existent companies solely for the purpose of getting control of his money for ASHEMIMRY to transfer it to his own accounts, or in one case to his brother-in-law's account, which I imagine we're trying to find out now has made its way back to Mr. ASHEMIMRY. So the whole thing was a scam from the start, and there's no basis for any kind of instruction that this was puffing. I do want to address the questions that were raised regarding the information memorandum. The information memorandum does not help them in this case. The information memorandum hurts them. It says, among other things, that the Ash Trust is going to invest its own money, as she pointed out, up to $3 million. And he was told by Khalid that ASHEMIMRY, in fact, had invested his own money. So that doesn't help them. The information memorandum identifies a board of directors, real estate experts from the United States. These gentlemen were deposed, and they said, we weren't on the board. We had no idea that this Mr. ASHEMIMRY was identifying us as members of a board of directors of a company that we had no involvement with. That I think, is actionable fraud. The information memorandum says that Ash Trust is going to be paid solely out of the profits of the business that SHEIK bin NAFA was being induced to invest in. Well, there never was a hotel purchase. There never was a profit. What happened was that Mr. ASHEMIMRY set up some documents without any disclosure whatsoever to SHEIK bin NAFA called professional service agreements that entitled him and Ash Trust to be paid 1% of the offering price of any offer he happened to make for a piece of property. So he could just make up numbers, which is what he did. He just made up numbers. He'd send a letter to some company in New York and say, I hereby offer $30 million, $40 million. He'd just make up a number. I hereby offer that. He'd do that on a certain day. On the same day, sitting at the same desk, he'd then invoice himself saying, well, you just made an offer pursuant to the terms of the professional services agreement. I get 1% of the offering price, so I'm invoicing you for the offering price. And then he'd write a check out of the account where the only money was SHEIK bin NAFA's, and he'd pay himself this huge fee. And he, by the way, did these professional services agreements before there was ever any contact whatsoever with bin NAFA. So I think that's very good evidence of what we think we proved, which was this was a scam from the start. There was never any intent on the part of Mr. ASHEMIMRY, which was a one-man company, basically, not a 100-person company, to invest in hotels. His plan from the start was to get control of the money. Once he got control of the money, just to pay himself. Now, he was sophisticated enough in most instances not to write the check directly to himself. A lot of it we couldn't even find. All we know from his records was that he sent it to the Philippines, he says. We've got no record showing that. He just says it went to the Philippines on a real estate project there. By the way, not an American company, not an American investment. We think that money is now back in his pocket. We don't think it was ever sent to the Philippines, but we don't know. It just disappeared. The other money, he says he sent it to the Saudi stock market. There was no authorization or discussion with Sheikh bin Nafa about sending this money that was solely for hotels in America to be sent to the Saudi stock market. And then, incredibly, he says the full amount of the investment, 100%, was lost in the Saudi stock market. Now, today we might believe that could happen, but back then, to say that you'd lose 100%, 100 cents of every dollar is lost completely in every stock you happen to invest in is just incredulous. I just think the evidence of fraud here was just so overwhelming. And Sheikh bin Nafa testified many times that he did rely on these representations. One I thought that Judge Sawaya brought up that I thought was very important was involving that second investment. He was telling him, invest another $3 million, and I'll couple that with the $3 million you already put in, and together you'll have enough to own 70% of this hotel, and then I'll put in the other money. Well, at the time that representation was made, the other $3 million we now know was completely gone. There was no money. So that's got to be fraudulent to say I'm going to take your additional $3 million and put it with the $3 million that you've already got to give you a 70% ownership when the $3 million that you already invested is already gone. It's not in the account. It's not there. And at the same time, he's telling him this. He's also telling him that you're getting these great returns, and I'll just grant you more stock in this fictional company. So he's going to grant him more stock because he's making such great money. He wasn't making any money. The money was all gone. It had already been stolen. That's a fraudulent representation. So the second $3 million that's invested, it's invested in reliance on that.
Can we talk a little bit about the interest?
Yes, I wanted to turn to the interest issue. As we've explained in our brief, I don't think that was preserved at all. And Judge Palmer, I think you correctly pointed out that they made a completely different argument below than what they're making in the appeal now. They're saying the treble damages ought to be taken away completely, is what they said below. And but I did want to supplement what I'd said in my brief. And the appellant made this argument that we just accept the proposition that you cannot treble prejudgment interest. Now, let me say at the outset that we don't even know that the $5 million, whatever, includes prejudgment interest. We don't know. We know Sheikh bin Nafa invested $6 million. He got an award of $5 million and change.
Well, but I thought that the jury question where he got the $5.62 million was as to Harrell Investments. And I thought that was undisputed that was a $3 million investment.
Well, as the first part of what you said, the answer is I'm not sure. As the second part, you're right. That was a $3 million investment. The other $3 million didn't come until the following year.
Well, I'm looking at the verdict form, and question one on the verdict form. On the funds originally invested in Harrell, we, the jury, find, et cetera, and every place else, they zero. It was zeros except for that one, which was 5.62, and my interpretation of the evidence was that it was clear that was a $3 million investment.
That was a $3 million investment.
So, and admittedly, when you do the math, and I did it, kind of roughly, the balance comes out pretty close, within about $60,000 of what the interest ought to be if they accepted I think it was an accountant's testimony, but she makes the argument, and there's something to it. The statutory interest rate, I just looked at the statute, it's on post-judgment, not pre-judgment. So, were they free to say, well, I think some other percentage of interest is appropriate.
Well,
And did they waive the issue by not differentiating interest and principal?
right, I think that they need to bring that to the attention of the trial court and give the trial judge the opportunity to deal with that issue. And I don't think that they preserved that. I don't think they preserved it before it went to the jury. I don't think they preserved it after it came back from the jury. And I think that if they were going to challenge that portion of the award, they had to do so with a timely filed motion for remediator.
Well, but a remediator only applies to the damages awarded by the jury. And I guess my question is, if they don't dispute that your client, I mean, assuming that they're liable at all, they don't dispute that your client's entitled to prejudgment interest. So there's really nothing to remit. The issue is simply whether or not the prejudgment interest gets trebled. And I guess so my question would be, do you agree or disagree with their argument that the prejudgment interest does not get trebled?
I disagree with that argument, and I'll explain why. The civil theft statute says that you treble the actual damages. Now, there are a host of cases in Florida, and the one I'll cite to you from this district that says that interest is an element of compensatory damages. That is a loss. One of the cases that they cite, Greenberg versus Grossman, page 15 of their reply brief, specifically says interest is an element of compensatory damages. This court in Adam versus Versailles, Sur la Mer Condominium, 973 Southern 2nd 466, said that, quote, interest is an element of pecuniary damages. That is a loss that SHEIK bin NAFA suffered. When his money was stolen from him, he lost not only that money, but then he lost the interest on that money. That is an actual damage that he suffered. None of the cases that they cite in their reply brief deal with that kind of a scenario. What they deal with is where you have money that was lost, and then you treble that, and then you add interest on the trebled amount as prejudgment interest. This is not that situation. This, under the scenario that you've posited, is that there is a finding of liability and an amount of damages is fixed, and then interest is added, to which we are entitled to as a matter of law, because it is an element of compensatory damage. That is a damage that was suffered. So it is an actual damage. Once you get there, once you say that's an actual damage, then all that's left is the ministerial act of trebling it. There's a case that I think says this, but I'll tell you it's not 100% clear. And again, I haven't cited this because this is my response to their reply. But it's O'Donnell versus Arcores, Arcoires, Inc., found at 561 Southern 2nd 344, page 345. It's a Florida 4th District case in 1990. And there they said that the trial court properly computed treble damages by including prejudgment interest as an element of damages. So I believe that prejudgment interest is, as a host of cases say, an element of compensatory damages. Therefore, it is an actual damage. Therefore, you just do what the trial court just was supposed to do what the statute says, which is treble the actual damages, which is
I
what
want
he
to
did.
make sure that this is not an issue, because I haven't seen it anywhere, and that is the way that the damages were trebled. They were multiplied 3 times, and then that figure was added on to the damage amount of $5,600,000, whatever.
But
So that's not. That was never raised below. I just want to make sure that was never raised below, and the way that was trebled is not an issue that we're talking about here. It's only whether the interest was added to it, improperly added to it. Is that right?
yes, that's 100% correct. So I think I've fully responded to, I think, the issues that they raised in their reply. If the panel has any other questions, I'd be happy to answer.
Thank you,
Thank you.
counsel.
Very briefly, let me
Let me,
address that, Ron.
let me have you address the preservation issue that I raised before. Your motion to alter or amend the final judgment below, which is where the argument was made,
Right, Your Honor.
argues that The trial judgment was in error because trebling damages of $5.62 million is erroneous because plaintiff is only entitled to treble actual damages. Actual damages cannot include interest. It is impossible to determine the actual damages to be trebled under the civil theft statute. Thus, the final judgment should be altered or amended by deleting any treble damage award under the civil theft statute. That's what you asked the trial judge to do below. The trial judge didn't do that below. That was not error for the trial judge not to do that below, correct?
I agree.
What did you ask the trial court to do that he, in error, failed to do?
I think it was sufficiently pointed out that that it includes prejudgment interest.
But you yourself said it's impossible to determine the actual damages. How can you ask us to say the actual damages is $3 million and treble it after you told the trial court it's impossible to determine what the actual damages are?
I think that it's quite clear that the actual damages were the $3 million, and this sort of
But
goes
what was
to
the basis of your allegation in the motion to the trial court that it's impossible
Judge, if I had
to determine?
I wasn't trial counsel. I don't know what was the basis of his allegation. I haven't asked him. But it
aren't you
seems
stuck
quite
with
clear.
that?
I think that the issue is sufficiently raised, that the judge was told you can't treble prejudgment interest, and that the judge went ahead and trebled prejudgment interest.
No, the judge was told he couldn't treble the judgment at all, the verdict at all, correct?
That is, in fact, what that sentence reads. You asked a question as there were two awards made. There was $5.5 million award for the first investment, the $3 million investment under fraudulent investment, under fraudulent inducement, conversion, and civil theft. And then there was a separate $5 million award made under the conversion, solely under conversion. The jury found that although there was fraudulent inducement as to the second $3 million that was invested, it caused zero damages. But under conversion, they found $5 million. So there was...
Wouldn't that be a double recovery for theft? And that
No, because there was $3 million. There was $3 million investment that gets trebled.
So you're saying that there was a separate $5 million award, and then the theft was $5 million, and that was trebled to 15, and then you add the two.
Yes.
So, okay, I got you.
Yes. Their argument about O'Donnell, as he said, it hasn't been cited, but in fact the Fourth DCA later addressed that case in Vining versus Martin and said that we know that there is the single sentence, and it does not make clear whether this court was authorizing prejudgment interest on the treble damages or the compensatory portion of the award. Thus, we do not read O'Donnell as restricting our opinion at bar. And Vining is one of those where they said you can't give prejudgment interest 3 times. Whether you say I'm taking the prejudgment interest award and I'm trebling it, or you award prejudgment interest on 3 times the compensatory amount, you come to the very same thing. And therefore, it's inappropriate. Thank you, Your Honors, for your time.
Thank you both.